In the United States, employee turnover is common, and people leave their jobs for many reasons. An employee may leave the labor force entirely by retiring, or can leave one position to pursue other endeavors. Since the Great Recession of 2008, labor market conditions have improved and stabilized in the ensuing economic recovery, and employees have become more comfortable with voluntarily leaving or changing positions in the workforce. In this module, we approach the circumstances of employee turnover, and when, how, and under what circumstances an employee leaves her job, and how an employer can structure a work environment to reduce workover turnover. Furthermore, we address the employee responsibilities that persist even after she leaves her position. Who may resign? Most American workers are employed on an at-will basis, meaning that they can leave their jobs at any time for any reason. At-will employees are not legally obligated to provide employers with advance notice or cause when they quit, although it's good form to provide employers with a dated written resignation that includes the reason for the resignation. It's also common practice to provide 2 weeks' notice where practical. This is an important professional courtesy that gives the employer an opportunity to hire a replacement and provides a worker with a record of the time and circumstances of the resignation. In contrast, contracted employees may be restricted from terminating their employment at will. For example, if an employee signs a 3-year employment contract and after year 1 wishes to relocate, the employee could request to be released from the remainder of the contract, but if the employer refuses, the employee is obligated as a matter of contract law to complete the contract. Constructive discharge. When an employment relationship must come to an end, employers often prefer for employees to resign rather than firing them. Companies face potential legal and financial responsibility when firing an employee, so circumstances may arise where the employer will try to compel an employee to resign. A constructive discharge occurs if an employer makes working conditions so intolerable that a reasonable person would not be expected to deal with them. Constructive discharge may be grounds for a wrongful termination lawsuit. It's often seen in a work environment where an employee feels threatened by coworkers based on habitual sexual harassment. However, for an atmosphere of sexual harassment or hostility to lead to a finding of constructive discharge, the offending behavior must be sufficiently severe or pervasive to alter the conditions of the victim's employment and create an abusive working environment. It's a fact-specific determination, and a plaintiff carries a heavy burden of persuasion. The workplace environment. The quality of the workplace environment matters. Federal, state, and local laws establish basic guidelines and requirements for workplace conduct and personnel policies. But these laws also grant an employer a great deal of flexibility. As such, an employer's human resources department will want to provide all employees with policies designed to create pleasant working environments to boost worker morale and retention. Not only have organizational psychology studies demonstrated that creating pleasant working environments can substantially benefit operational efficiency, they've also shown that improving the quality of a workplace environment can ultimately save money, as employees stay at jobs longer. Another way for an employer to create high-quality atmosphere is to push for employee privacy protections. During the hiring process, an employee will disclose personal information, and during employment, an employer may require that an employee submit to background checks, polygraph tests, and other scrutiny that may affect the employee's privacy. While some of these practices are implemented for legitimate business practices, an employee does not completely relinquish her rights to privacy once she starts a job. There are Fourth Amendment rights against government infringement on privacy, and laws such as the Fair Credit Reporting Act and the Health Insurance Portability and Accountability Act that protect employees from unreasonable use of information in background checks and disclosures of private health information. Employers who set clear guidelines with policies and promote privacy can ensure positive emotions, well-being among their employees, and can attract more talented employees, decrease labor turnover, and improve financial performance. Employees are less likely to quit their jobs when they feel valued, secure, and respected in the workplace. And hiring new employees is costly for businesses, as replacing an employee who quits typically costs the employer about 20% of the employee's salary. Still, even where best efforts are made to promote a positive work environment, some employee turnover is inevitable. Nonetheless, leaving a job doesn't end an employee's necessary responsibilities. Ongoing responsibilities after quitting a job. After the employment relationship is terminated, several of the legal rights and obligations continue to apply to both the employer and the employee. We'll focus on these responsibilities of the employee. Trade secrets. The law typically protects the confidentiality of trade secrets. After an employee leaves a job, she may not reveal the employer's trade secrets or use them in a way that violates the intellectual property rights of the former employer. Trade secrets include a business's private plans, devices, processes, tools, mechanisms, formulas, and other information of a unique nature. A trade secret may be a chemical compound for a new pharmaceutical drug, a privately developed accounting system, or marketing plans, or a customer list. However, for information to be protected as a trade secret, an employer must take an affirmative step to protect the information from disclosure, such as by password-protecting electronic documents or clearly labeling papers as confidential. Trade secrets can be particularly valuable in new and innovative industries. As an abject example of the danger of employees leaving jobs with knowledge of trade secrets, consider the Waymo versus Uber case. Waymo, a self-driving vehicle company that formed as a spin-off of technology giant Google, sued Uber, which was also developing its own self-driving vehicle technologies to grow its ride-sharing business. Waymo alleged that Uber had stolen Waymo's trade secrets and intellectual property. The case revolved around Waymo's former top engineer who left the company to take a job with Uber in January of 2016. Allegedly, the former Waymo employee downloaded confidential data about the company's autonomous vehicle technologies just weeks before quitting his job and becoming the head of Uber's self-driving car division. Uber responded to the lawsuit by claiming that it never had access to Waymo's trade secrets and that merely hiring a former Uber employee is not an infringement on Waymo's intellectual property. Waymo asked the courts to stop Uber from moving forward with its self-driving vehicle business entirely, because the company claims it was built on stolen proprietary information. The case eventually settled in February of 2018. The Waymo versus Uber case stands out as an example of how difficult and nuanced the protection of trade secrets can be. The question of whether an employee disclosed protected, confidential information that he learned while working at a former job can be difficult to resolve. After all, an employee cannot help but apply his knowledge and experience to a new job, even if some of these skills were developed while the employee was working with proprietary trade secrets. After leaving a job, workers should be cognizant of the ongoing liabilities associated with trade secrets and take care to not unintentionally disclose protected information. Restrictive covenants. Employees often agree to contractual provisions that limit their rights to engage in conduct that would be adversarial to their current or former employer's business interests. These agreements, known as restrictive covenants, may relate to the nature of the employer's business, reasons for termination, or future business plans. Common types of restrictive covenants include confidentiality agreements, non-solicitation agreements, non-compete agreements, and non-disparagement clauses. Some information is confidential by its very nature, and employees are prohibited from sharing it even in the absence of a signed confidentiality agreement, as in the case of trade secrets. Because trade secrets may be difficult to identify or enforce, many employers require employees to sign confidentiality agreements that cover much broader categories of information than trade secrets. Confidentiality agreements prevent employees from sharing information that they learned of during their employment. Confidentiality agreements can be very broad in scope and subject the employee to liability or damages if breached. Non-compete agreements commonly accompany non-solicitation agreements. Non-compete agreements restrict employees from working for their former employer's competitors after leaving their jobs. However, employers are limited in the degree to which they can restrict their former employees' job prospects. While many employers require their employees to sign non-compete agreements, courts don't always enforce them because of the degree to which they restrict former employees' freedom of contract. Courts will only enforce non-compete agreements if they are reasonable in three ways: in the amount of time it purports to last for, its geographic scope, and the scope of activity it purports to prohibit. The Texas Supreme Court, for example, has stated that it will not enforce non-compete agreements that are indefinite in nature. Reasonableness is a fact-specific inquiry, and varies from industry to industry and job to job. Suffice it to say that a permanent or very long-term non-compete agreement, or an agreement that purports to stop people from working in an industry anywhere in the United States, is extremely unlikely to be enforceable. Non-compete agreements that restrict employees from working in a narrow field in a specified city for a year or two are much more likely to be considered reasonable. In fact, employers that require their workers to sign restrictive non-compete agreements must be careful to avoid liability for tortious interference with contractual relationships, which is a legal cause of action that arises when someone wrongfully interferes with contractual relations between parties. Trying to enforce an overly restrictive non-compete agreement to stop employees from contracting their work with other potential employers long after the employee leaves the job may form the basis for an unlawful interference claim. One Nevada case that reached the state Supreme Court illustrates a non-compete agreement's reasonableness analysis. In Jones v. Dieter, Dieter Lighting employed Larry Jones as an assistant in Dieter Lighting's equipment supplier and lighting service business. Dieter personally drafted a non-compete agreement, which Jones signed in addition to an employment contract. Pursuant to the terms of the agreement, Jones agreed not to compete with Dieter in the lighting retrofitting business for 5 years within a 100-mile radius of Reno, Nevada, after the employment relationship ended. As consideration for the promise, Dieter agreed to pay him 50 cents per hour in addition to the $6.50 per hour wage. If Jones did compete by going to work for a competitor or starting his own lighting retrofit business, the liquidated damages clause stated that Jones would pay Dieter $50,000. Dieter fired Jones 3 months after he started work. The next day, Jones began work as a salesman for one of Dieter's competitors, and Dieter sued to enforce the non-compete agreement. The Nevada Supreme Court, however, ruled against it and refused to enforce the agreement. The court reasoned, after careful consideration of all the relevant factors, we conclude that the covenant is not reasonable. Although it appears that developing a customer base for the lighting retrofitting business is difficult, we nevertheless believe that a 5-year duration is not reasonably necessary to protect Dieter's business interests, and places too great a hardship on Jones. Therefore, the covenant is per se unreasonable, and therefore unenforceable. A non-disparagement clause is the 4th common restrictive covenant. This is a contractual agreement that limits a former employee from making public statements that negatively impact a former employer, its reputation, products, services, or employees after terminating the employment relationship. A typical non-disparagement provision is straightforward, such as, employee agrees that she will not disparage the company, or any of its officers, directors, or employees. For purposes of this section, disparage shall mean any negative statement, whether written or oral, about company XYZ. What constitutes disparagement differs from court to court. In one Ohio case, an employer claimed that a former employee disparaged it by calling his old supervisor, the company's executive director, a slime bag. The court disagreed with the employer and found that this comment did not breach the agreement, characterizing it as a trifling figure of speech. Like other restrictive covenants, the non-disparagement clause cannot be overbroad, or else it might violate Section 7 of the National Labor Relations Act, which provides an employee with the right to unionize, to join together to advance their interests as employees. In one case, the United States Court of Appeals for the District of Columbia Circuit found that Quicken Loans' non-disparagement provision in its mortgage banker employment agreement unreasonably burdened employees' rights because it prohibited employees from publicly criticizing, ridiculing, disparaging, or defaming the company or its product, services, policies, directors, officers, shareholders, or employees. The court found the clause to be a sweeping gag order because it directly forbids them to express negative opinions about the company, its policies, and its leadership in almost any public forum. Professional practices related to quitting a job. Quitting a job can be a very stressful experience, but as tempting as it may be to quit a job in an abrupt and even disruptive manner, doing so may adversely impact the professional relationships and future job prospects of the person. To preserve reputation, relationships, and future opportunities, employees may want to follow certain best practices for quitting their jobs. Planning and forethought is key to smoothly transitioning out of a job. First, 2 weeks' notice of pending departure is standard good business practice, as it allows employers to find a replacement to deal with the transition. This is particularly true in jobs that require specialized skills or training, so employees in these fields may want to offer their employers even longer notice periods. Second, an employee who's leaving a job should make sure that her supervisor is the first person to know that she's leaving. This may mean discussing it in a meeting, an email, or a conversation with management, depending on what's appropriate for the workplace environment. Once an employer is notified that an employee is leaving, the employer and employee can work together to figure out the best way to efficiently transition the current employee out of the workplace. Finally, some employers request exit interviews, in which employees are asked questions about their experiences working at the company when they leave their jobs. Feedback offered during exit interviews should be constructive, as this can be a good opportunity to help the employer improve the workplace. However, workers who quit their jobs because they're unhappy with their employer may wish to refrain from too much venting of dissatisfaction to preserve professional relationships and future opportunities. References. Employers are under no obligation to provide references for former employees, and companies often have restrictive policies regarding what former managers can say if asked for a referral by a former employee. Former employers may face potential liability if they supply incomplete, inaccurate, or inappropriate information to other organizations. Any policy regarding referrals must comply with applicable anti-discrimination laws, such as the Civil Rights Act or the Age Discrimination in Employment Act. As a result, it's not uncommon for former employers to refuse to provide references. Where an employer gives a former employee a negative reference that is untrue and opens the former employee to ridicule and public scorn, the employer may be liable for defamation. In one case, a factory worker was fired after his coworker reported a threat that he allegedly made to sabotage the equipment. When providing the worker with a written notice of termination, his supervisor indicated that the reason for the firing was the worker's threat to sabotage the equipment. The termination notice was circulated to several other managers in the company. The worker sued the former company for libel and defamation based on the economic and reputation damage that he suffered as a result of the publication of the notice. In this factory worker's case, the jury awarded the former employee $15,000 in compensation for lost work and damage to his reputation, and an additional $2,500 in punitive damages. The case is a bit of an outlier, and the defendant successfully petitioned for a new trial based on procedural flaws. However, it does demonstrate that negative communication about employee performance may create civil liability, so employers should be careful when making public statements about former employees that could damage their reputations. Conclusion. Quitting a job can be a difficult decision, but almost all workers will do it at some point in their careers. The average American worker stays at a job for less than 5 years before finding something new. When quitting a job, workers should consider the conditions of their current and prospective workplaces. If a workplace is hostile or otherwise unreasonably poor, an employee who leaves her job may be entitled to recover damages from her former employer on a theory of constructive discharge. From the employer's side, fostering a positive work environment can decrease turnover and increase productivity. From the employee's side, leaving a job in a manner that is considerate and sensitive to the needs of the employer can help the employee's reputation and career in the long run.